I'm Darius Spearman, and you're watching African Elements. The Voting Rights Act of 1965 was a major victory of the Civil Rights era. It finally did away with poll taxes and literacy tests that effectively kept black voters from the polls. In the last decade, though, the Voting Rights Act has been severely weakened. Now a new challenge has emerged. In October 2022, the Supreme Court will hear a case that could once again give states unfettered ability to suppress the black vote. We'll see how, coming up next. Thank you for watching African Elements. If you're already a subscriber, welcome back. If you're new to this channel, we produce content in Black and Africana studies and bring it right here where the people are at. To support this content, be sure to drop a like, comment, and subscribe. Or you can become one of the history makers in our growing Patreon community. This is the first of what may be an ongoing series of hot topics, current events that should be on our radar for those of us in the activist community. For a deeper dive into today's hot topic, click the link above, where I've compiled a collection of articles offering full in-depth coverage. In this hot topic, we look at Moore v. Harper, a pending United States Supreme Court case arising from North Carolina's redistricting after the 2020 census. First, a quick review of the history of voting rights. On February 3, 1869, the United States ratified the 15th Amendment to the Constitution. The amendment provides that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. In doing so, it codified the right to vote for black men. Black women gained the vote with ratification of the 19th Amendment in 1920. The amendment specifically stated that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Since then, however, individual states have adopted a series of diabolical means to prevent black Americans from exercising their right to vote. Such measures have included the Grandfather Clause, a provision allowing those who had enjoyed the right to vote before 1867 and their descendants an exemption from the restrictive voting requirements enacted since the 15th Amendment. While keeping within the letter of the law, the measure effectively ensured that only black voters would be subject to those restrictions. Such restrictions included poll taxes and literacy tests. Other measures have included the white primary, the first round of voting in which only white voters could vote for the candidate of their choice. Additionally, gerrymandering is the practice of manipulating electoral boundaries in order to favor one political party over another. Through the Civil Rights era in the 1960s, African Americans beat back these attempts to deny their right to vote using both the courts and the U.S. Congress. In 1915, the Supreme Court struck down the Grandfather Clause in Gwynne versus the United States. In 1944, the Supreme Court ruled the white primary unconstitutional in Smith versus Allwright, based on the 14th Amendment's Equal Protection Clause. Finally, in 1965, Congress enacted the Voting Rights Act in response to widespread racial discrimination and voting practices that the states established since ratification of the 15th Amendment. The Voting Rights Act of 1965 removed poll taxes and literacy tests as barriers to black voters. Additionally, the Voting Rights Act prohibits any state or locality from imposing barriers to voter registration or casting ballots based on race, color, language, religion, sex, or national origin. It did so by requiring certain jurisdictions, mainly in the South, to get permission from federal officials before changing their election procedures. The act required those jurisdictions to pre-clear any changes to their election laws with the Department of Justice. The so-called pre-clearance requirement, known as Section 5, was intended to prevent states from creating new rules that discriminate against minority voters. Section 4B sets the formula for which jurisdictions will be subject to the Section 5 pre-clearance provision. In 2013, the Supreme Court ruled in Shelby v. Holder that Section 4B is an unconstitutional violation of the 10th Amendment. In the court's opinion, the coverage formula conflicts with equal sovereignty of the states by using a formula based on 40-year-old facts having no logical relationship to the present day. With no procedure for determining which jurisdictions will be subject to preclearance, The decision effectively struck down Section 5 of the Voting Rights Act. Since then, many states have moved forward with restrictive voting laws without going through the lengthy process of getting approval from the Department of Justice. Most notably, Texas passed a strict voter ID law only 2 hours after the court rendered its decision. Opponents argue that this measure discriminates against low-income people and minorities because they are less likely than white voters to possess the government-issued photo ID the law required. Later in 2013, Alabama passed one of the country's most restrictive voter ID laws, requiring voters to show a government-issued photo ID at polling places. The state then went on to close 31 of 67 Department of Motor Vehicle locations, all of which coincidentally happened to be in majority black counties. That brings us to the most recent case that the Supreme Court will review in its upcoming session. In Moore v. Harper, the North Carolina Supreme Court ruled that the state's Republican-dominated legislature violated the state constitution when it drew congressional districts that favored Republicans at the expense of Democrats ahead of the 2022 elections, a practice known as gerrymandering. The court found the redistricting maps unconstitutional, ruling that Republican leaders were motivated by partisan concerns instead of a desire to create fair districts. In October, the Supreme Court set to hear arguments in the case of Moore v. Harper. In addition to gerrymandering, the case involves voter suppression and a little-used legal theory called the independent state legislature doctrine. An independent state legislature regards state legislative assemblies as having their own constitution and laws separate from the federal government. The doctrine stems from a narrow reading of the U.S. Constitution. Article 1, Section 4 states, "Each state shall appoint in such a manner as the legislature thereof may direct a number of electors." The Supreme Court has interpreted this section to mean that the states have complete authority over the appointment of electors. That would include the districts they are elected from. This interpretation gave rise to the idea that there should be no interference between the executive and legislative branch in the selection of presidential electors. Conservative Supreme Court Justices Neil Gorsuch, Brett Kavanaugh, Clarence Thomas, and Samuel Alito have all endorsed versions of the legal theory in previous court opinions. Their support signals that they will vote in this case to overturn prior legal precedent, which considers such cases highly partisan and thus unjusticiable and prevented the country's highest court from weighing in on partisan state issues, including gerrymandered election maps. If the Supreme Court buys into this doctrine and rules in North Carolina's favor, it'll reduce oversight on state legislatures and could affect the outcome of statewide elections for the foreseeable future. This would mean that state legislatures, their own makeup the result of heavy gerrymandering, could contort congressional districts at will to ensure that one party has the advantage, playing with how much every individual's vote really counts. Theoretically, states could even set rules to disregard the results of a popular vote and appoint slates of electors after losing a presidential contest, allowing politicians to subvert democracy. In short, the Moore v. Harper Supreme Court case threatens to return the United States to an era before the Voting Rights Act of 1965, in which the states had unchecked ability to ensure an electorate of their choosing. Considering the current makeup of the United States Supreme Court, it seems likely that Black Americans will have to gear up for a renewed movement for voting rights. Please comment below on how you think we can best meet this challenge. I'm Darius Spearman, and if you made it this far, I hope you'll consider joining the history makers in our Patreon community who make it possible for me to continue to make this content. Thank you so much for your support. If you'd like to become a history maker, you can join them for as little as $1 a month and get early access to ad-free videos. Otherwise, thank you for watching, and until next time, I'll see you in the comments.